All offices 503. Feel free to start.
All right, case today is the State of Midlands versus Jordan Ryder. Both sides here and ready to proceed?
Yes, Your Honor.
All right, defense?
Yes, Your Honor.
All right. Anything we want to take up pre-trial?
Yes, Your Honor. May the state make appearances before the court?
Yes.
Good afternoon, Your Honor. My name is Stephen Becker. I'm joined in court by my co-counsel, Will Wilson.
Good afternoon, Your Honor.
Good afternoon.
And Arvind Godet.
Good afternoon, Your Honor.
Good afternoon.
Together, we represent the people of the state of Midlands in today's proceeding. Now, would you like to hear introductions from defense counsel or the rest of our preliminary matters?
Why don't you take care of everything you need to, and then defense will be able to do that too? Yes,
Yes, Your Honor. We have a binder of documents to tender to the bench. These include the indictment, the stipulations, orders on motions in limine, relevant case law, and other relevant documents which both sides will be referring to throughout today's trial. The opposing counsel has seen this and has no objections.
All right.
May Mr. Godet approach and tender?
Yes. For you to get up here. We need a teamwork. Thank you.
Next, Your Honor, we'd just like to draw the court's attention to one of the items in that binder.
All right.
It's the fourth orange tab, the orders on motions in limine on the second page.
Okay.
Under admissibility of interrogation, we'd just like to note for the court that the defendant's interrogation may be read onto the record by counsel for either party or through a witness without additional foundation and at any time once the record is open. However, of course, both sides may raise evidentiary objections as they see fit.
Certainly. Thank you.
Next, Your Honor, we'd like to invoke Rule 615 of the Midlands Rules of Evidence, constructively sequestering all witnesses, barring party representatives.
Okay.
The state has no party rep today.
Sounds good.
Next, we'd like to ask Your Honor's preferences regarding well movement and asking permission. Would you like us to ask permission before approaching opposing counsel, the witness, or the bench?
Always the bench. You don't have to ask to approach opposing counsel, but if the witness is an opposing witness, always ask.
Yes, Your
Make
Honor.
sure, in terms of movement, if people are using visual aids, you do not need to ask permission, just move so we're not interrupting one another. And if anybody abuses that, we'll just handle it then.
Yes, Your Honor. And with that, the state is ready to proceed.
Sounds good, thank you. All right, anything from the defense?
Yes, Your Honor. May we introduce ourselves?
Absolutely.
Good afternoon, Your Honor. My name is Virginia Shalino, and today I'm joined by Nell Beekler.
Good afternoon.
Good afternoon.
And Catherine Campbell.
Good afternoon.
Good afternoon.
Today we'll be representing the defendant, Miss Jordan Ryder.
Good afternoon.
We simply have one document to tender. This is a notice of intent to offer character evidence. Mr. Becker has seen and signed the document.
Sounds good.
May I enter the well?
You may.
There you are.
Thank you.
And with that, the defense is ready to go.
Sounds good. All right, opening from the state.
Yes, Your Honor. Counsel, members of the jury, Your Honor, may it please the court. On July 14th, 2018, the defendant pushed back. It's a Saturday afternoon, a sweltering summer day. The sun beats down on a mother and her daughter as they hike up the Lacrone Loop Trail in the Calkins campground. It's not easy. Next to the windy, rocky path are steep drop-offs. And as they approach the edge of a cliff, they begin to argue. The daughter screams at her mother, and in response, the mother wrenches away her daughter's hiking stick and jabs it in her direction. Suddenly, she pushes the girl backwards, and she falls 40 feet to her death. That 12-year-old girl was Parker Page. That mother was the defendant, Jordan Ryder. And members of the jury today, you'll know that the defendant pushed back. But why did she do it? Let's go back a few years. The defendant was in prison. And while she was in prison, she started to imagine a new life with her daughter after release. She made ambitious plans. about grand adventures, treasure hunting, climbing mountains. But there was one issue with the defendant's high expectations. Her daughter. While the defendant was away, her daughter Parker was diagnosed with something called brittle bone disease. This debilitating condition, it simply wasn't compatible with the defendant's plans. And today, you'll learn the defendant grew more and more frustrated with the reality of her daughter's weakness. Eventually she took Parker on one of those adventures anyways, forcing her limping and complaining daughter to hike the Lacrone Loop. And as they approached the peak, Parker began to scream and the defendant's high expectations came crashing down. You'll learn that the defendant's resentment turned into a moment of blind rage as she ripped away her daughter's hiking stick and used it to push her off a cliff. She pushed back. And because Parker Page was under the age of 13, the charge we're pursuing against the defendant is aggravated murder. Now, that means we don't have to prove the defendant planned and intended or even wanted to kill her daughter. But we will prove, beyond a reasonable doubt, that the defendant pushed her daughter off a cliff, causing her death. And we'll do it by calling 3 witnesses today. The first is the defendant's sister. While the defendant was in prison, Parker was under the custody of the sister. We expect that she'll tell you about Parker's condition, how it affected her, about the defendant's high expectations, and about the volatile weeks leading up to Parker's death. On July 14, 2018, the defendant pushed back. We'll call a hiker today who saw the 2 of them on the Lacrone Loop Trail. And we expect he'll tell you. He saw them arguing on the edge of a cliff, saw the defendant jab a hiking stick towards Parker, and later found Parker's body at the bottom of that same cliff. But how did she end up down there? Today, you'll hear from a forensic pathologist who has that answer. We'll call a doctor to this stand today who conducted Parker's autopsy. And she'll tell you about a bruise on Parker's collarbone that was the exact same size and the exact same shape as the hiking stick found with the defendant, the hiking stick she used to push back. Now, in just a moment, Ms. Beekler will come before you, and I anticipate she will try to shift the blame. I don't know exactly what she'll say, members of the jury, but trust the evidence. You'll find there is only one reasonable explanation to today's case, and that's the one that we are going to show you today. At the end of today's trial, we'll ask you to find the defendant guilty. Thank you.
Opening from the defense, Your Honor.
Yes, please.
Your Honor, Mr. Wilson, members of the jury, may it please the court. This is Jordan Ryder. She's a single mother, and today the state is telling you that she killed her only child. Mr. Wilson just got up here and told you that Ms. Ryder pushed back. But members of the jury, you're going to hear about how the police pushed past the evidence to get a conviction. Because what the state didn't tell you was that Ms. Ryder didn't cause her daughter's death. Parker's death wasn't anyone's fault. Parker just wanted to go take some pictures of the sunset. And when it got dark, she got lost. She tripped and she fell. Parker's death wasn't anyone's fault. So how did we get here? How did the state get the story so wrong? Today, you're going to learn that the police found a victim, and so they looked for a villain. It's July 14th, 2018. Jordan Ryder and Parker Page go for a hike, and they come back together. Parker tells her mom that she wants to go take some pictures around the trail, and she'll be right back. So Jordan waits, as minutes turn to hours, but her daughter doesn't come back. It's the night of July 14th, and Jordan Ryder is panicking. She's looking around the campsite, calling out for her daughter, but Parker doesn't answer. Parker is gone. It's July 15th, and the police arrive at the campground. Jordan Ryder tells them that she doesn't know where her daughter is, that she needs their help. And what do the police do? They arrest Jordan Ryder. The police found a victim, so they looked for a villain. But members of the jury are going to find there isn't a villain in today's case. It's not enough for the state just to tell you there is one. Because when Miss Ryder walked through those doors and sat down at this table, she was presumed innocent. And the burden rests on the state's table to prove to you that the opposite is true. That the only reasonable explanation for Parker Page's death is that Jordan Ryder caused it. But the state won't meet that burden. We, as the defense, we don't have any burden. We don't have to call any witnesses. We don't have to tell you any story. But we believe you deserve the truth. So we're going to show it to you by walking you through that police investigation. What was missing and what they didn't consider. So what was missing from that police investigation? You're not going to hear from a member of that investigation. Members of the jury, you're not going to hear from the lead investigator. And you're going to find out why the state chose not to call him. It's because the state wasn't able to find anyone who saw Jordan Ryder push her daughter off a hiking trail. You're not going to hear from any witness who will tell you that was the case. Instead, you're going to hear from other witnesses who will tell you a different story. You're going to hear from the campground owner. He'll take the stand and he'll tell you that he was on the trail with Jordan Ryder and Parker Page that day. He's going to tell you that he didn't see Miss Ryder become aggressive. He didn't see her become violent. That when Parker Page and Jordan Ryder were on that trail together, everything was fine. So what didn't the police consider? You're going to hear about text messages that Parker Page sent on July 14th, the same time that the state is alleging she died. But you're going to hear that there isn't any cell service out on those hiking trails. So for Parker to send those messages, she had to be far away from those trails. You're also going to hear from another medical expert who reviewed the state's own report. It's going to tell you that the state didn't consider Parker's medical history when making their conclusions. And if they had, it would have made it more likely that Parker died later on July 14th and that her death was an accident.